All right, get this, 60% of Americans do not have any kind of estate plan, like a will. You probably think that if you pass away, everything is going to go to your spouse or your kids, but that's not always what happens. Mitch Mitchell is an estate planning counsel at Trust and Will. He's here to explain the importance of having a will and the different options out there and to answer your questions. So this is your chance to get your question answered by someone who really knows the answer, not the next door neighbor, not the friend who thinks that they know. 336-379-5775. When you text in your question, you'll get your question answered live here on air. All right, so Mitch, let's just break down what's the difference between a will and a trust.
Well, a will is a document that everybody should have. It's a document that says what happens to my property when I die. It also has the option to designate guardians for children when you die. But importantly, it's a document that goes through probate when you die. So it has no legal effect while you're still alive, but it is a document that you need to set up while you're still alive. And compared to a trust, that also is a document that you set up while you're alive, but you do some of the administrative work beforehand. And if you do it right and get all of your assets into the trust, then you can avoid the probate process.
You can avoid the probate process if you put what in a trust?
Things like your family home into the trust. You title other assets into the trust. Any assets that are in my name when I die, those are assets that go through probate unless they have a beneficiary designation like life insurance.
Gotcha. Okay. All right. So a will sets it up for like your kids and things of that nature of who your kids would go to guardian wise. But the trust sets up your assets so that it does not go through probate.
That's the design of the most common type of trust, often called a revocable living trust. Yes.
Okay. And you can get both of those done kind of at the same time.
Yes.
Okay. All right. So why should people have an estate plan? Because I think a lot of people think that, well, whatever I have is going to be left to my kids or left to my spouse.
Yeah, and that's a great question. And I think there's this misconception that, yes, that there's an automatic process here. But the last thing that we want to happen when we're no longer here is that our family's burdened with not knowing what types of decisions we want to make or who we would have wished to have been in charge. And so this really is an opportunity to unburden them from those types of decisions. You get to make those decisions in advance and certainly don't rely upon defaults.
I think a lot of people will just be like, well, they'll just figure it out. But figuring it out can actually take a really long time, and it can also mean a loss of some of those assets.
Yeah, that's true. So there's a story recently about a woman who was on her honeymoon, and unfortunately, her new husband died while on the honeymoon, and she couldn't get access to his Google Photos account because he hadn't set up in a plan naming her to have authority for those things. So there's delay there that wouldn't have been there if he had a plan in place naming her, giving her clear authority to access assets, including online accounts.
Okay, I think we don't even think about that, the whole social media stuff and online accounts of things that we think we own. All right, so what happens if people don't put the measures in place?
Well, from my experience, there's uncertainty coupled with this. People don't know what to do, number one. And so without a clear plan, they're having to guess. Maybe they don't even know where to look. They don't know, should I go to an attorney? Should I ask a friend who's gone through this before? And so you really have an opportunity here to empower them with information instead of sort of leaving them in the lurch.
Okay. How often should someone make changes to their will?
Well, a good rule is once every 3 to 5 years, or if there's been a major life event. So major life events are, the addition of a new child into the family, a death of a loved one who was named in your plan, either as somebody who you were going to leave in charge or who's going to receive property, as well as change in marital status.
Okay, I think a lot of people would think, you know what, I've told so-and-so that I want them to take my kids if something were to ever happen to me. But unless it's actually written somewhere, does that actually hold up?
No, generally not. So guardianship is a strange process that kind of mystifies a lot of people. It's always going to be a court process where a judge decides who's going to be guardian for those children if they don't have a parent to take care of them. And you have an opportunity in your plan to nominate someone. So you get to state your preference, but ultimately the judge is going to weigh what's in the best interest of those children. And, you know, the best evidence of what you thought was the best interest of your children is having it clearly notated in your plan.
Okay. And is it something where you have to like put like the name and like that kind of stuff, or is it just something that you can just mention them, or do you have to have like their social security number, all that kind of stuff?
Right. So generally it's done in a will, or it's done in a document that's signed and witnessed the same way as a will. So you name those people by name and you say, in the event there's a need for guardian of my children, I nominate this person to be guardian. And then the judge will weigh whether that person ultimately qualifies and should be that guardian.
All right, we talked about wills, we talked about trust, we talked about probate. A lot of people they've heard about probate, but they don't know what it is. So can you take us through that?
Yeah, so probate is a court process, and it's a process, number one, to determine, did somebody leave a will? And so I left a will, and I clearly stated what I wanted to happen to my property, and I clearly stated who I wanted to be in charge. So a judge makes the determination, was that in fact my will? And then second, who did I name as executor or personal representative to be in charge of my property? And that's much like the nomination I described with the guardian. Is the judge will decide, is that person ultimately qualified? And then we'll enter an order saying, this person is now executor, they have authority to administer the estate. So it's a court process where at the outset, we're determining, is there a will? Who's going to be in charge? A judge decides who will be in charge. And then if there is a will, well, the executor will be tasked with distributing the property according to the terms of the will. If there isn't a will, then there are default rules that say, here's who the property goes to, my heirs. So the state decides who gets my property at that point.
Gotcha. And that process of your heirs getting it and that kind of stuff in the court deciding, that can take a while. That's not like a month process.
No. So that's consistent feedback from my time in private practice as a lawyer, is that nobody expects for probate to take that long. And it always takes long, even with those expectations, it always takes longer than people think once they get into it. And so generally, and it does vary by state. So, a jurisdiction like North Carolina, it may not be as long, but it's still long to people who are going through it, because you're dealing with things like a delay to access to assets. I mentioned the Google Photos story, but sometimes like there's an acute need to have access to a financial account because the bills keep coming in. We want to make sure the mortgage is paid. And any delay in things like that, where maybe there's not a will, can be felt pretty seriously by your loved ones that you've left behind.
Okay. All right. We're taking your questions, and there are already some in the queue. So we'll be right back in just a few moments. 336-379-5775.